Hello everyone and welcome back. As you can probably tell just by the background, I'm not in the office. In fact, Audrey and I are actually in San Francisco for the weekend. We're attending a business workshop which is focused on law firms and helping us run more efficiently and doing a better job for our clients. We do this every 3 months. In any event, while I was actually on the way here, we received a call from somebody, a gentleman whose father had been Baker Acted to one of the facilities that we litigate against regularly. Now, the father, I believe he was in his 60s, had been Baker Acted, and the facility said to him, you can't come get your father, we have a court order. And Brittany, who runs my intake department, said, well, how long has he been there? And the son said, I think just a little bit less than 72 hours, but they're telling me we can't come and get him, there's a court order in place. And I said to Brittany, it sounds to me like we need to file something. And the question the son had for us was, is it possible that the facility actually has a court order? And I said, I guess it's possible, but if there had been a court proceeding, your father would have known about that because he would have been present for it. They don't do these things in secrecy unless somebody is completely incapacitated to the point where they physically couldn't appear. And I've represented clients who were completely rendered catatonic by the medications the facility gave them intentionally to destabilize them, and I had to go to the hearing without them. But in this case, there's no evidence of that. And if the father doesn't believe that he went to a hearing, or somehow, that there was a hearing that took place without him knowing about it, then I doubt very, very much that there's a court order in place. First of all, this particular facility I litigate against all the time, and they are by far the worst abuser of the Baker Act anywhere in the state of Florida that I deal with. Second of all, typically a facility doesn't file a petition for a court order this quickly. What they typically do when they get towards the 72 hours is they try and get the patient to consent to stay voluntarily, typically by just coercing him or lying to him, or whatever they need to get him to sign. And if they don't get the consent for whatever reason, then they go file their petition. And that starts a 5-day clock ticking, because the hearing has to be conducted, the placement hearing has to be conducted within 5 days. So that the chances that there has been a court order in place, I would say, are somewhere between slim and none. And I said to Brittany, I said, this is the time we need to file right now, because I want to get to court first. And you know from other videos I've told you, whoever gets to court first typically wins. And I like to play offense. I don't like to play defense. Let them respond to me. I don't want to respond to them. I want to be driving this train. I want to be directing the litigation in this case. And this facility knows me, because I've dragged them into court lots and lots and lots of times, and they know I'll fight. They know I don't play games, and if I file a petition, I'm coming for them, and I'm coming to win, and I'm coming to get my client out. And most of the time, they'll just capitulate. So I want to share that with you. If a facility tells you they got a court order and they can't produce the order, and your loved one doesn't remember that they ever went to a hearing, chances are they're lying to you. That's not unusual with the cases that we see. So I want to share that with you, and I appreciate you tuning in. Thank you.